I'd like to bring in my guest to discuss the upcoming sentencing for 16-year-old Aiden Fucci, which is set to start tomorrow. As you know, Fucci pleaded guilty to first-degree murder in the death of his 13-year-old schoolmate, Tristyn Bailey. Back in February, the Florida teen faces up to life in prison with a minimum sentence, by the way, of 40 years. He pleaded guilty, as I told you, in February. But the defense has filed several motions in light of tomorrow's sentencing. One of them is asking the judge to prohibit testimony from psychologist Gregory Pritchard, referencing Pritchard's deposition where he said a diagnosis could not be provided without an in-person evaluation. So I still have with me attorney and former prosecutor Matt Mangino, along with state attorney Dave Arenberg. And Dave, since you're from Florida, I want to start with you. First, how do you expect the judge to rule on this motion?
It's a tough one, Linda, because this guy pled guilty, and so the judge wants to create a clean record so that there is absolutely no chance of any shenanigans on appeal. Well, or any chance to mess up with this verdict that he's going to give, which will, I think, be life in prison. Now, under Florida law, the defendant here, since he's underage, is entitled to a review after 25 years. That's why he pled guilty. He's playing the long game. He wants to get released in 25 years. He wants to show he's accepting responsibility, and he would like this expert's testimony to be removed so that the record is in his favor 25 years from now when the court reviews all the materials. He's entitled to due process, and the judge may decide, yeah, he's already pled guilty, let's give it to him. So I think probably he gets what he wants, but it's definitely not a done deal.
Wow. Well, commenting on Dave Arenberg's predictions here, Matt Mangino, this young girl was stabbed 114 times, apparently. 114 times. So with that, what do you expect the judge to say and do with regard to the sentencing of Aiden Fucci?
Well, this is a horrible crime. 13-year-old girl, as you said, stabbed over 100 times. But again, we're also talking about a 14-year-old defendant. And, the law has evolved over time. This is certainly not a death penalty case because the Supreme Court has says that, juveniles under the age of 18 cannot be subject to the death penalty. And then there are also decisions with regard to life without parole as it relates to juveniles and having a reasonable opportunity at parole someday, even on a heinous crime like this. So, we're seeing the workings of the United States Supreme Court as they apply to juveniles in the state of Florida and across the country. But here, we're talking about a sentencing, not a trial. So the court has wide latitude to let a lot of information that otherwise would not be admissible at a trial to be presented to the court for purposes of sentencing. So I expect that the court is going to be pretty liberal in what's permitted to be presented to him during this sentencing phase.
Okay, well, Matt Mangino and Dave Arenberg, you'll be staying with us as we go to our break. And on the other side, we'll be talking more about what's going on in courts across the United States and back to the Michael Keatley trial, specifically in Florida. I should say retrial. Is he guilty? Is he a mass murderer? Well, we'll talk about that, and we'll see on the other side. Stay with us.